is Sherry Shear, and I'm a partner in Labor Rights Law Office. And with me is Rebecca Jackson. She's an associate lawyer at Labor Rights Law. I understand, Rebecca, you've got a series of questions for me today, but before we kind of start going through those questions, why don't you tell me a little bit about how you came up with these questions to begin with?
Okay. Well, before I became a lawyer, I was a registered nurse and I belonged to 2 unions. And so I've been exposed to the collective agreement and grievance processes, but I never really understood their importance until I became a lawyer. So I would just like to ask you some questions today and clarify some of those little details.
Sounds great. Let's get started.
All right.
What's your first question?
So starting from the beginning, what exactly is a collective agreement?
So a collective agreement is a contract that's been negotiated between a union and an employer. And this contract contains terms and conditions of the employee's employment, as well as rights and obligations that the employer, the union, and the employee may have during the course of employment. One really important point about collective agreements is that each one can be a unique creature of its own because it results from negotiations between the union and an employer, who may have their own distinct interests during the negotiation process. And therefore, that's one of the reasons why it's so important for an employee to be familiar with their collective agreement and take the time to review it and understand its terms.
Great, thank you. So a collective agreement is basically like an employment contract?
Yes, in a unionized setting, exactly. That's what it is.
A collective agreement is a really big document and can be overwhelming. If I'm going to have a look at it, where's a good place to start?
First and foremost, I want to add that employees should at least review their collective agreement once. They should take the time and review it in its entirety. But having said that, I understand in certain circumstances, you may not be able to do that. So if you are going to review one provision, I would recommend that you take a look at the grievance article and the process that's outlined under that article. There are a few reasons why it's important to do that. Firstly, these kind of provisions outline how you need to file a grievance to begin with, whether you can, as an employee, file the grievance on your own or whether you're going to need the union's assistance in doing that. It also outlines in what format it needs to be filed. Can it be oral? Will you simply be able to tell your supervisor that you have a grievance that you'd like to file with them? Or does it need to be in a little bit more formal manner, submitted, for example, in writing? It also outlines one really other important feature, and that's the time limits associated with filing a grievance. Pretty much all collective agreements, the majority of them will have a provision setting up time limits for filing a grievance. In some cases, it may be as little as few days, and in some cases, it may be as long as a month or even 2. But it's important for employees to know how much time they have in order to be able to file their grievance, because if you do file your grievance out of time, the employer is able to refuse to deal with the grievance on the basis that it wasn't filed in compliance with the terms of the collective agreement. And for an employee, that may leave them without a remedy to begin with. So therefore, it's really important to familiarize yourself as an employee with the grievance article if you're just going to review one provision.
All right, that sounds pretty complicated. Can you tell me what exactly is a grievance?
A grievance is, in the simplest term, it's a complaint that's being put forward either by the employee directly or by the union on behalf of the employee. In some rare circumstances, actually, the employer can also file a grievance against the union. But again, as I said, those are really rare. Majority of the instances where a grievance is filed is by an employee or a union against their employer. And that's all it is. It's just a complaint outlining any concerns the employee may have about terms and conditions of their employment, whether the employer's compliance with those terms and conditions, and sometimes with respect to obligations of an employer under specific legislation, such as human rights obligations.
So what can be grieved?
A lot of things, various issues can be grieved through a grievance, but most importantly, the breaches of the terms and conditions of an employee's employment as outlined in the collective agreement can be grieved, or a breach of legislation. As I referenced earlier, human rights obligations outlined in federal or provincial legislation are implied into the collective agreement. and because those are very important rights, and so there's case law establishing that these legislative provisions are implied into the collective agreement, and therefore the breaches of them can also be grieved as well. But if ultimately, if an employee has a question as to whether the concern that they have is a grievable concern, our recommendation is to go and speak with your shop steward or your union representative, because they can further clarify what your options are and whether the concern or the issue that you may have as an employee it can essentially be grieved under the collective agreement process, or should you pursue it through some other means. There are a few instances where the concerns raised may not be grievable, and they have to do with compliance with, for example, WorkSafe BC obligations or obligations of the Workers' Compensation Act. But aside from those, the majority of issues and concerns can be grieved. And if you require further clarification, speak with your union representative or shop steward.
Okay, so going back just a step, you said that something's implied into the collective agreement. Does that mean that those become a part of the contract, the collective agreement?
Yes, exactly. Certain provisions are stated expressly in a collective agreement. However, when we talk about terms being implied, that means even though they're not stated expressly or explicitly within the collective agreement, you can still rely on those legislative requirements or obligations and file a grievance as a result. An example I've already given, one is human rights obligations. All employers are bound, as well as unions, are bound by the provisions outlined in the federal or provincial human rights legislation, and therefore it essentially becomes a term, even though it's not stated expressly within the collective agreement, it becomes a term of that collective agreement.
Okay. And you said you can talk to your shop steward or your union rep. I hear all sorts of different terms. Are they different? Are they the same? What does that mean?
A shop steward is essentially probably one of your colleagues or co-workers who is more familiar with the terms of the collective agreement and has been appointed by the union to act as your shop steward, meaning that they're able to assist you with understanding the terms and conditions of the collective agreement at the work site, essentially. While on the other hand, a union representative is someone who is probably employed directly with the union, but is able to assist you with any questions or concerns that you may have arising from the collective agreement or the employer's conduct. The union reps tend to get involved later on in the grievance process, not at the initial stages. Shop stewards tend to typically assist employees with filing grievances or even answering the question of, is the concern that I have a grievable issue under the collective agreement?
Thanks.
Thank you for joining us, and we hope that you found this video to be informative.
Be sure to check out part 2 of our What Every Union Member Needs to Know series as we dive deeper into the topic of grievances, such as how to file a grievance and much more.